Just to let you know, if you're planning to live stream the pre-trial, it's okay. Just the trial itself.
Pre-trial's okay, all right.
Pre-trial's
Thank
okay.
you.
You're welcome.
You read my mind.
I just said to the judge, I know they're gonna ask me, so let me
That's right.
just preempt this.
Maybe let them know.
Okay.
Because I don't know if they will. In the trial, we're not going to live stream. We're going to just say.
Correct.
Yeah. That'll be easy, so.
And we.
What's the trial willing,
Yeah, he's the.
Yeah.
but not election, right?
Yeah.
No.
Maybe I'm getting a raise or something.
Actually, Clint, give you a raise.
You were looking for us? So it's gonna be an hour anyway. No, I'm saying the hearing, how long it's gonna be. Well, let's just wait before we hook up, because they're still back there talking, so.
How many overtimes?
Yeah, that was crazy.
Was it only one?
They just, it's one
Yeah,
of
they
them.
just did one.
Oh, wow.
And it's different when you play like the regular.
Weekend before Halloween.
Yeah,
Weekend before
I
Halloween.
fell asleep too, because I knew I was gonna be.
You guys ready? So we're at the
All rise.
All right, thank you. May be seated. If you have a cell phone, can you make sure it's off for me, please? You could be seated, everybody. What'd you do to get the air not blowing? Yeah, I can't believe it's been off. Yeah. So you know you're gonna. All right, so we're on the record this morning, case 692-604, State of Ohio versus Bionca Ellis. Good morning, Miss Ellis. We're here this morning just for our final pretrial. This case is set for trial on Wednesday. A couple motions that are pending with respect to the trial that I'm going to ask parties to discuss. Before we do that, I just want to make sure I just go through some logistics that we just spoke about so that we're all on the same page. So, Ms. Faralia, thank you for being here because I know you're currently in trial. The expectation is that we all think that you'll complete your trial maybe Tuesday, but for sure we give you the day of Wednesday. The trial here is to start on Wednesday, but in fact we had put that in our calendar for really a questionnaire of the jurors. So if I can have you on Wednesday morning just to greet the jurors with my opening comments before they fill out the questionnaire. I think we all agree the questionnaire will be completed. Those 70 jurors will be excused for the day, and we'll reconvene on Thursday with all 70 jurors being here. We'll only bring 40 up initially and begin our voir dire and our questioning of those 40 jurors, and that's how we'll begin on Thursday. We are off on Friday, and then we'll continue to voir dire the jury until we have one impaneled. I did mention to all of you that I'll have 16 jurors, so I'll have 4 alternates as well with respect to the case. The courtroom's a little tight, but I think I know there are 2 different thoughts process of how we should conduct a voir dire, but I'm comfortable with this being in the courtroom the way it is. It may be that I may be able to move some tables a little bit further back if you think it's too close, but I'll try to do that adjustment with the sheriff and my staff today as well. And then finally, with respect to the trial, we're going to move forward, in a fashion that's timely. Of course, my job, Ms. Ellis, is to protect the constitutional rights regarding a trial, and so that's my job, and I'm going to continue to do that. All of you proposed a questionnaire to me, and I've modified that questionnaire, and we've talked a little bit about that. I'll ask Kathleen to make sure that that's provided to you this morning with the modifications that I suggested. And I'd ask by the end of today that you give some thumbs up or some suggestions, and I'll make my final changes to that questionnaire and provide that. Again, we'll be handling matters on the 12th floor. Again, we'll do that outside of the public view regarding this jury and the questionnaires and those questions as well. And then with respect to the let me ask, anything further with respect to those discussions that we talked about, anything from the state of Ohio? And I'll note for the record that Ms. Pateo and Ms. Feralia are here, but also Mr. Miranda has joined the table, Anthony Miranda for the state. And counsel are present, Mr. Mack and Mr. Johnson for Ms. Ellis. But just regarding the jury, anything that I may have missed, Ms. Feralia, regarding our discussions in chambers?
No, Your Honor, and thank you for the courtesy.
Okay, thank you.
We should be concluding either tomorrow evening or Wednesday morning at the latest.
Very good, thank you. Mr. Mack, anything I may have missed?
Nothing further, Your Honor.
Okay, thank you. All right, so then let's go to the 2 motions. So let's go to the motion first, just to hear arguments, and I'll take it under advisement, is the motion to sequester the jury during the trial. Mr. Mack.
Judge, on behalf of Ms. Ellis, this is a high-profile case with significant media coverage, and we requested that you sequester the jury throughout the entire trial. And we want to ensure that Ms. Ellis receives a fair trial by making sure that there's no outside influence to taint the jury. We want to make sure that jurors are protected from threats and tampering. We want to make sure that the decision is based solely on the evidence that comes out of this courtroom, rather than what they see through social media, rather than what they see through the coverage of this case. I've tried a number of cases in your courtroom. This is the first time I've ever asked to sequester a jury. And you don't need me to say it. Exhibit A is right here in your jury box right now. This case has had the kind of exposure that I believe is necessary to protect the defendant pursuant to the 6th Amendment of the Constitution. Juror safety is important, but the integrity of the process is what is most important. No matter what she's charged with, she deserves a fair trial. Now, I understand that there's a burden financially that comes with this. I understand that there's a burden by any juror that undertakes this and want to be a part of this process. But there are other cases that have had jurors sequestered for far longer than what we're asking. We believe that the case should last a week, maybe a little more, I'm not sure, depending on how many witnesses get paired down. But the financial burden and the burden to each individual juror does not outweigh the fairness and the integrity of the process for her. So I've asked that you do it. You have the authority to do it pursuant to Ohio Criminal Rule 24H, and I think it's a reasonable request under these circumstances. Once the jurors have been impaneled, and if you don't do this, then you've lost control to manage what may be coverage through social media and other outlets. Thank you.
Thank you. On behalf of the state?
Thank you, Your Honor. May it please the court, the state recognizes that the court has discretion with respect to sequestering. Sequestering at the beginning of the case is very unusual in this county. It's appropriate to guard against improper media or media improperly influencing jurors, but there are standard jury instructions that the court can provide the jury to guard against any risk that they're improperly listening to media or social media. And sequestering at the start of this case would cause a substantial inconvenience to the jurors who have family outside of this case. So for that reason, we would ask the court to deny the motion.
All right, thank you. Anything further?
Just, Judge, I don't think that unusual is the litmus test. I mean, it's not the test. And instruction is given in the beginning of a case, but you don't know what folks are going to do once they're home, once they're around their family, around people that they trust. And inconvenience certainly is not the standard. So there's a reason why you have the discretion. I think you should employ it.
All right, thank you. All right, I'll take the matter under consideration, and I'll have a ruling before the end of the day here. With respect to the second motion, I know we had some further discussions, and I've had an opportunity to review some of the evidence that may come in, or at least may be presented by the state. That second motion was a motion in limine to exclude irrelevant, repetitive, and unfairly prejudicial photographs. And so, Mr. Johnson, why don't I hear from you?
Your Honor, if it's correct, I believe in Cambridge, we had opportunity to get some access to what we wanted to see, and I think we probably have a stipulation that will pare down a lot of the unnecessary photos, even though they might be inflammatory or prejudicial for the required state to present.
All right, and so we'll note, Ms. Bralia, that when looking through, I think, the autopsy photos, we've narrowed those from 200 plus to 9, and I've had a chance to review those as well. And is that acceptable to the state?
Yes, Your Honor, there's actually 10. And in addition to what Mr. Johnson indicated, there also will be some crime scene photographs, drone footage, and videos from different parts of the day prior to the homicide and then after the homicide. But all of those will be shared with the defense prior to the commencement of trial if possible. And as standard, once a trial begins and something needs to be shown, that's always shared with the defense. And if they have an objection, then you, being the arbiter of the law, make that determination.
Yes, and so at this time, let's start the trial, in a fashion that evidence will be presented. If there's an argument to be made, we can have that argument at sidebar. I'll make a decision during the trial as well. All right, I appreciate your ability to have those open communications, and thank you for doing that as well. So let's go then just some final thoughts. I have signed and executed a media order, and so this, in the courtroom today, we'll just have one pool camera that'll be in the corner, as opposed to, of course, a number of cameras being in here. It will not interfere with you and your production as lawyers. There's a number of things that the camera crew cannot do, like recording conversations or recording sidebar. With respect to media and witnesses wanting to be excluded from video, I did specifically outline that procedure, and I'm hoping it doesn't happen when I say, who's your next witness, and then you say, well, this witness doesn't want to be videotaped. So it needs to be something that provides me ahead of time so that I can actually have it on the record without the jury being in the courtroom, and then I'll make a decision. And then I can instruct the camera pool on whether they're allowed or not allowed to video. Of course, jurors will not be videoed, and if a witness specifically has opted, and I grant that, I'll allow that to happen. But I want to be able to let media know ahead of time as opposed to spontaneous in the courtroom. So if you could be mindful of that, I appreciate that as well. And then in and out privileges, I did discuss as well. We're not going to allow that movement in and out. There'll be some precautionary means of coming in and out of the courtroom as well that the sheriff has put together for me. And then lastly, I wanted to note that the parties have had discussions at my request about whether there was a potential opportunity of resolving the matter, and I think all of you have had those diligent discussions back and forth. But Ms. Faralia, just for the record, before we begin on Wednesday, there's no mark on the file as far as an offer being made as far as a result to this case. Is that correct?
That is correct, Your Honor. Nothing has been offered at this time.
Okay. But fair to say there have been discussions between the state and Mr. Mack and Mr. Johnson?
That is fair, Your Honor.
Yeah, thank you. And anything to add to that, Mr. Johnson or Mr. Mack?
Judge, in all fairness, we haven't asked for anything.
Very good. All right, thank you. And then lastly, for the state, anything before we recess for the day? Otherwise, I think if you are still in trial, Ms. Faralia, the judge is going to give you a chance to at least meet the jury when I bring them down on for the beginning of the questionnaires. So I would see you on Wednesday morning. But anything further that you would want to address with me?
Not at this time, Your Honor. Thank you.
Yeah, thank you. And again, just whoever's going to follow up with my bailiff regarding the questionnaire that I finalized today as well. And then Mr. Johnson, Mr. Mack, anything I may have missed or anything you want to address before we recess?
Not before we recess.
All right, very good.
Thank you.
All right, thanks, everybody. We'll adjourn.